Mifepristone comes to court, and a judge rains down fire and brimstone on the Food and Drug Administration. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Late last year, the Federal Office of Legal Counsel published an opinion that sending mifepristone and misoprolol through the mail did not violate the Comstock Act against sending through the mail the kind of drug a woman might take to end a pregnancy. But now, mifepristone itself is in court, or rather the FDA is in court, defending its approval of it. Last week, a federal judge stayed the approval of the drug while he hears a lawsuit challenging that approval. This case will very likely land in the Supreme Court because already another judge in another circuit has ruled to the essentially opposite effect, although that affects 17 states only. More to the point, this judge has already frostily disapproved of that OLC memo. I'm going to dissect the judge's memo and show you how it says far more about mifepristone and how it came to win FDA approval than its sponsors might wish known. But first, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which depicts a child in the womb with this caption: "Not your body, not your choice." And as I intend to show, we are talking about a drug that a lot of women took and now wish they hadn't. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do, so long as it's legal tender. Now, can I have your attention, please, everyone? Class is in session. Not a law class. I am not a lawyer, but I am entitled to put MD after my name. So this will be a medical science class and a history class. First, what is mifepristone? Mifepristone is today the most popular chemical abortifacient. The drug firm Roussel Uclaf developed it in 1980 and brought it to market in France in 1987. It became available in the United States in 2000. Typically, one takes it as a pill during the first 63 days of pregnancy. One then takes misoprostol, a prostaglandin analog, to expel the remains of the unborn child. The problem for regulators, and what Biden's Office of Legal Counsel relied upon, is that mifepristone has other uses. In low doses, one can use it for emergency contraception, though the preferred drug for that is levonorgestrel, which in this country goes under the trade name Plan B. More to the point, doctors have used the mifepristone-misoprostol combination to treat women following miscarriage. Doctors have also prescribed it for leiomyoma, that's uterine fibroids, and endometriosis. These other uses prompted the OLC to state in their December 23, 2022 opinion, to which I've left a link in the description, that, quote, "We conclude that Title 18 United States Code Section 1461 does not prohibit the mailing or the delivery or receipt by mail of mifepristone or misoprostol where the sender lacks the intent that the recipient of the drugs will use them unlawfully," close quote. And because one might use the drug for these other purposes, the Postal Service has no way to know, so says the OLC. Mr. Ed Whelan, the Antonin Scalia Chairman for Constitutional Studies at the Ethics and Policy Center, challenged that opinion. You will recall my talking about that before. I even suggested that pro-life advocates might want to file a citizen's complaint against the government to force it to enforce the Comstock Act. But pro-life advocates did not wait to file a citizen's complaint. Instead, they challenged the FDA itself to defend its approval of the drug. Alliance Defending Freedom has a case in the U.S. District Court for the Northern District of Texas, Amarillo Division. The case of Alliance for Hippocratic Medicine et al. Versus FDA et al. Charges that the FDA violated its own processes in approving Mifepristone. ADF, in their article on the case, say, and again I quote, "By illegally approving such drugs, the U.S. Food and Drug Administration failed to abide by its legal obligations to protect the health, safety, and welfare of girls and women. The FDA never studied the safety of the drugs under the labeled conditions of use, ignored the potential impacts of the hormone-blocking regimen on the developing bodies of adolescent girls, disregarded the substantial evidence that drugs like these cause more complications than ending a pregnancy by conventional surgery, and eliminated necessary safeguards for pregnant girls and women who undergo this dangerous drug regimen." Close quote. Though I am slightly paraphrasing here. They presented their argument on March 15th and asked Judge Matthew J. Kacsmaryk to enjoin the FDA from listing mifepristone and misoprostol in that combination as approved drugs. On Friday, April 7th, Judge Kacsmaryk stayed that approval. A stay in this context is less than an injunction, but more than simply vacating the approval. If the court just vacated the approval, the FDA could simply start again. But this puts everything on hold unless in the week to come the Fifth Circuit Court of Appeals says otherwise. I've left a link in the description to Judge Kacsmaryk's memorandum and order and the site at the site Court Listener so that you can read it and follow along if you have access to a desktop or laptop. That opinion reflects great anger with the FDA and impatience with the OLC. In fact, the plaintiffs have been challenging the FDA since 2002, 2 years after the 2000 approval. In an obvious bid to dismiss a "you waited too long" argument, the court bluntly said, and I quote, "Simply put, FDA stonewalled judicial review until now." Close quote. To be specific, the judge said immediately afterward, and again I quote, "Before plaintiffs filed this case, FDA ignored their petitions for over 16 years, even though the law requires an agency response within 180 days of receipt of the petition. But FDA waited 4,971 days to adjudicate plaintiff's first petition, and 994 days to adjudicate the second." Now, the second petition came in 2019. Had FDA responded to plaintiffs' petitions within the 360 total days allotted, this case would have been in federal court decades earlier. Instead, FDA postponed and procrastinated for nearly 6,000 days. Close quote, with emphasis in the original. After that, the judge describes what Mifepristone does, which I will spare you, and then describes the approval process. Tellingly, at first the FDA showed reluctance, but months later, before the election of 2000, the FDA approved the drug under Subpart H. That subpart exists for drugs to treat serious or life-threatening illnesses. In other words, the FDA regarded pregnancy as an illness, and a serious or life-threatening one at that. Now, I want to point out two things this judge did that I think will make a significant difference moving forward. First, the judge explicitly dropped the word fetus and wrote instead of the unborn human or unborn child. In a footnote, he writes, quote, "Jurists often use the word fetus to inaccurately identify unborn humans in unscientific ways. The word fetus refers to a specific gestational age of development, as opposed to the zygote, blastocyst, or embryo stages. Now here he cites a medical text explaining the gestational stages of an unborn human. Because other jurists use the term unborn human or unborn child interchangeably, and because both terms are inclusive of the multiple gestational stages relevant to the FDA approval, 2016 changes and 2021 changes, this court uses unborn human or unborn child terminology throughout this order as appropriate. Close quote. Second, the judge named the Population Council as applying to get FDA approval for Mifepristone, and that is correct. It's historically correct. And he explained who those people are. Just listen to this quote. The Population Council was founded by John D. Rockefeller in 1952 after he convened a conference with population activists such as Planned Parenthood's director and several well-known eugenicists. The conference attendees discussed the problem of quality. They concluded that modern civilization had reduced the operation of natural selection by saving more weak lives and enabling them to reproduce, thereby resulting in a downward trend in genetic quality. Close quote. Whoa. First he discards a certain dry term and takes a subtle dig at his fellow jurists for retaining it, and then he gets to the heart of the matter. Hold that thought while I get to the dreadful record of Mifepristone in clinical use in these United States. But first, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. You feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Now, Judge Kacsmaryk then details the record of Mifepristone under its subpart H approval. Quote, deaths of at least 8 women, 9 life-threatening incidents, 232 hospitalizations, 116 blood transfusions, and 88 cases of infection. Close quote. What a record. Any other drug with a record like that would be off the market in a trice, as I, a former clinical laboratory administrator, am in a direct position to know. The problem is that the FDA stalled on the 2002 petition for 14 years, finally rejecting it in 2016 during the Obama administration. And again, I quote, that same day, FDA approved several changes to the Mifepristone-misoprostol drug regimen, including the removal of post-approval safety restrictions for pregnant women and girls. FDA increased the maximum gestational age from 7 weeks gestation to 10 weeks gestation. And FDA also, 1, changed the dosage used to end a pregnancy, 2, reduced the number of required in-person office visits from 3 to 1, 3, allowed non-doctors to prescribe and administer these two drugs to end a pregnancy, and 4, eliminated the requirement for prescribers to report non-fatal adverse events from this regimen. Remember that last. It becomes important for judging later FDA determination. 2 of the plaintiffs petitioned again in 2019. A month later, the FDA approved a generic form of Mifepristone, and cut more corners in that approval process. And on April 12, 2021, the FDA allowed dispensation of distribution of Mifepristone and Mifepristone through the mail, citing the pandemic of, come now, you know what I'm going to mention, the virus that shall remain nameless. This act violates the Comstock Act, which forbids sending such drugs through the mail. Finally, in December 2021, the FDA rejected the second petition. The judge uses more than 55 pages to justify the stay. For much of this memo, he addresses concepts like standing, likelihood of prevailing on the merits, irreparable harm, and public interest. But in reaching his decision, Judge Kacsmaryk reveals even more chilling information. He speaks of such harms as adverse events overwhelming the medical system by creating medical emergencies and complications, having to complete an incomplete pregnancy termination to save a life that this drug has placed in danger, preventing the practice of evidence-based medicine and interfering with informed consent, and as many as 14% of women not hearing about the side effects until they're feeling them. The plaintiffs themselves raised the issue of Comstock Act violations. In addressing them, the court made a devastating observation. Biden's Office of Legal Counsel ruined their case with their ill-considered memo. The very act of writing that memo demonstrated that the pursuit of purely administrative remedies would be futile. Courts, in requiring exhaustion of remedies, do not require parties to make futile gestures. We have legal precedent in that effect. Furthermore, Judge Kacsmaryk tore apart that memo exactly as Ed Whelan did 3 months ago. The court didn't cite Whelan's 3-part series, nor apparently did Whelan file any briefs as friend of the court. Now, the judge did the tearing apart thing to show that the plaintiffs are very likely to prevail on the merits, because mailing these drugs does violate the Comstock Act. In fact, the law is as plain as one could write it. So said the judge. Now, remember the court's observation that the FDA eliminated the requirement for prescribers to report non-fatal adverse events from using these drugs? Well, the court then observed that in 2021, the FDA relied on adverse event reporting system data. Now, how could those data be complete if adverse events were not reportable? Thus, the court found the FDA's actions arbitrary and capricious. That puts the FDA in violation of the Administrative Procedures Act. I quote, "It is circular and self-serving to practically eliminate an adverse event reporting requirement and then point to a low number of adverse events as a justification for removing even more restrictions that were already omitted in 2000 and 2016. In other words, it is a predetermined conclusion in search of non-data, a database designed to produce a null set. But even if FDA's explanation were well-reasoned, the actions would still run afoul of the Comstock Act and therefore violate the APA." Close quote. In addressing the FDA's actions to protect Mifepristone before 2021, the court makes this bold statement: pregnancy is not an illness. Therefore, Subpart H cannot apply. This court also denied that Mifepristone and Mifepristone provide a meaningful therapeutic benefit. To the contrary, all too many women who use these drugs feel worse, not better, afterward. In 2 paragraphs, Judge Kacsmaryk gives a devastating critique of the 2000 approval process. First paragraph, quote, "The court does not second-guess FDA's decision-making lightly. But here, FDA acquiesced on its legitimate safety concerns. In violation of its statutory duty, based on plainly unsound reasoning and studies that did not support his conclusions. There is also evidence indicating the FDA faced significant political pressure to forego its proposed safety precautions to better advance the political objective of increased access to drugs of this kind, which was the whole idea of Mifepristone. As President Clinton's Secretary for Health and Human Services, or HHS, explained it to the White House, it was FDA that arranged the meeting between the French pharmaceutical firm Roussel Uclaf, who owned the Mifepristone patent rights, and the eventual drug sponsor, Population Council. The purpose of the FDA organized meeting was, and he quotes, to facilitate an agreement between those parties to work together to test Mifepristone and file a new drug application, close quote. HHS also initiated another meeting to assess how the United States government, i.e. the Clinton administration, might facilitate the successful completion of the negotiations between the French firm and the American drug sponsor to secure patent rights and eventual FDA approval. In fact, for their negotiations to be successfully concluded, the HHS secretary believed American pressure on the French firm was necessary, close quote. The very next paragraph says worse, quote, whether FDA abandoned its proposed restrictions because of political pressure or not, one thing is clear. The lack of restrictions resulted in many deaths and many more severe or life-threatening adverse reactions. Due to FDA's lax reporting requirements, the exact number is not ascertainable, but it is likely far higher than its data indicate for reasons previously mentioned. Whatever the numbers are, they likely would be considerably lower had FDA not acquiesced to the pressure to increase access to drugs of this nature at the expense of women's safety. FDA's failure to insist on the inclusion of its proposed safety restrictions was not the product of reasoned decision-making. To hold otherwise would be tantamount to abdicating the judiciary's responsibility under the APA to set aside agency actions that are arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law, close quote. The judge went on to castigate the 2016 changes and the 2019 genetic approval on similar grounds. Given what the judge had already said, finding substantial likelihood of irreparable harm becomes a no-brainer. The judge also found that stopping the approval somehow would be in the public interest. Not only did the administration and the FDA fail to take care that the laws be faithfully executed, they also advanced eugenics arguments. Bad move. Quote, though eugenics were once fashionable in the commanding heights and high court, they hold less purchase after the conflict, carnage, and casualties of the last century revealed the bloody consequences of social Darwinism practiced by would-be Übermenschen. Close quote. Wow. Did you catch what he just did? He as good as called those defendants National Socialists in all but name. And now a final analysis. As I said, I am not a lawyer, but I am a doctor in that I have a medical degree. Once upon a time, I was a clinical laboratory administrator. When Roussel Uclaf Lot 486 first broke into American medical literature, I was in postgraduate training in a major university-affiliated hospital's residency program. So I know all about the history of Lot 486, now known as Mifepristone, its original trade name, Mifeprex, and its sponsorship by the Population Council. That sponsorship should tell you all you need to know about the purposes that drug serves. I have said before that population is a theater of war. The Population Council wanted to lower the birth rate in America, and they have. offering to improve genetic quality becomes an excuse to trend population downward. Judge Kacsmaryk dropped a hint of that in his memorandum. Sadly, Judge Thomas Rice of the U.S. District Court for the Eastern District of Washington State, Spokane Division, has ruled opposite to Judge Kacsmaryk. He has ordered that Mifepristone research available to 17 states that remain available. 17 states that have sued to keep it available. This represents a split not only between district courts but also judicial circuits. So expect both these cases to land before the U.S. Supreme Court, possibly as soon as the 2023 term. And when they do, the interests of unborn humans will have their strongest advocacy yet. Furthermore, the interests of the elites will clash directly with those of civilizational America. Links to the description of the article, to the OLC memo, to Judge Kacsmaryk's memo and order, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and oursilverlives.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and links to that video I did once before about, I don't send those things in the mail just so fast, about low birth rate, and one other. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.